this page, but my thinking is actually.
I would never bother.
Okay, we'll call the committee back to order. We'll try to move quickly through this. So, Representative Cheney, Vice Chair Cheney.
Thank you, Mr. Chairman and committee. I had hoped that I'd get up here while you all were still worn out, but the chairman gave you a break, so I fear that you may have found a second wind. So be kind. So the bill you have before you, and just like the last couple of bills, this one I'll be asking if the committee would be willing to send it to general orders, and I've included the proposed amendment in your paper folder. Yes, I went old school. We're partying like it's 1999. You have a paper copy of the draft that would be the amended bill. And so as we go through this, I would ask that you look off of that for your reference. So what are these algorithms? We hear a lot about them. Essentially, and there are a lot of really smart people in this room that are going to bristle at just how overly simplistic an explanation this is. But essentially, it's a computer suggesting to a judge what kind of sentence or pretrial release you should have, based on the likelihood that you will commit another crime or not show up to trial. That, at its heart, is what this is all about. And that, at its heart, is not a bad thing. We like predictability. We like being able to get it right. I know our judiciary, our prosecutors, everybody involved in the judicial system wants to get it right. So in the print hearing, when I compared what was happening with some of these algorithmic systems to the movie The Minority Report, what I was really addressing were two key problems within the movie The Minority Report. And the first was that it was unconstitutionally punishing people that were doing no wrong. And number two is that they were hiding the errors that occurred. And so what this bill that you have before you would seek to do isn't to take away the tool, but to correct those same two problems, to take away the unconstitutional considerations that may be built into them, and to prevent the ability of any of these systems to remain secret and conceal errors. At its heart, this is a civil rights bill. The data shows that when these systems err, they do not err consistently across demographics. When they err with a Caucasian, they typically underestimate the probability that a Caucasian will reoffend, which is a public safety issue. And when they err with an African American, they overwhelmingly err that African American is more likely than they really are to reoffend or to not show up to trial, which is unconstitutional racial discrimination. And it is here. I included in your paper packet a handout from the Idaho Criminal Justice Commission 2017. Recommendation number 1 is a risk assessment tool. The tools that are available here may or may not be the same ones that the problems have been revealed nationwide, but there's been no standard, and there's been no guarantee of clarity and transparency in how they are used. I won't take time to go through it today, but I've also included for your reading a article on bias in these systems and what causes them. So like I said, the first issue is to take away unconstitutional considerations. Beyond race, there are also possibility of discrimination on the basis of other constitutionally protected classes, like gender, or as recently as about a month ago, one of the court administrators in I believe it was El Paso, Texas, I know it was Texas, decided that they were going to use fatherlessness in their model as a predictor of criminology. Now, there may be psychological or sociological explanations for that. However, parentage, legitimacy, is a constitutionally protected class. From way back when our intestate laws used to exclude intestate, the laws of wills and inheritance, our laws used to exclude illegitimate children, and that was struck down as unconstitutional. And so that is a protected class that's being built in that shouldn't be. So how is this happening? I mean, why in the world would there need to be legislation? I've heard that there are lawyers out there who like to file lawsuits. It's shocking to me, frankly. Well, the problem is when some of these systems have been challenged, the vendors who construct these systems have refused to hand over the information. They've refused to explain how it is that they've been trying to improve their accuracy on the basis that it's a trade secret. Now, there are ways of getting around trade secrets in litigation without telling the whole world about them, but they've been successful in just shutting things down and not having to give over any information whatsoever. So that's the second issue that this bill seeks to address. The minority report type issue that seeks to conceal errors in the system. I believe that our judges do want to do a good job, and if something's provided to them that's supposed to be an objective tool, it really should be an objective tool, because they're going to want to rely on it. But it should be just a tool, not a way to secretly use unconstitutional considerations in predictive models the way that big data likes to show you ads for shoes and cars on the website. And the public and defendants have an absolute right to see what's being used. As I've alluded to, these systems are used in two different key areas of the criminal justice process, one in setting pretrial release conditions, the other in setting sentencing. So as I talk about what the issue is, I'll fade in and out of each one to illustrate what the problem is. But the bill only relates to pretrial conditions. Constitutional violations shouldn't be seen as okay just because they're wrapped up in a computer program and hidden from sight. Individual rights are the priority in our criminal justice system, not efficiency. Not efficiency. We are intentionally inefficient in this country because we don't want a system that gets it right on average. We believe in a system that gets it right for each and every defendant to the degree possible. And so the bill itself, as amended, would simply require that these systems be demonstrated to be free of bias and would foreclose the possibility of refusing to turn over information when requested by a criminal defendant, not even a civil defendant, in a criminal case. And with that, Mr. Chairman, while I would more than happy to stand for questions, I know there are others that are about to testify that actually may answer some of those questions better than I can. So I would like to offer to come back up and close and answer any remaining questions at the end of testimony, if that's okay.
Very good. Did you have a question for Representative
Mr. Chairman, Representative Cheney, just a couple of quick questions. Are there county prosecuting attorneys, judges, whatever the case may be, are there being used in the state of Idaho these, I would imagine, computer-driven algorithms in pretrial hearings presently?
Representative Cheney.
Mr. Chairman, Representative Marshall, yes.
Follow-up?
Follow-up question. In the bill, on line 29, the pretrial risk assessment algorithms shall not be used in the state. And then nothing contained in this subsection shall prohibit the state or political subdivision of the state from operating a pretrial risk assessment algorithm for the purpose of validating its bias or effectiveness. I'm really confused about the language in that subsection which says shall not be used, and then we go on in that subsection and in subsection 3, 4, and 5 to talk about the use of the algorithms. So I guess in my own mind, I'm totally against any kind of computer-driven algorithms to determine anything in relationship to the accused. But I'm asking you to clarify the language here because it's a little confusing.
Representative Cheney.
Mr. Chairman, Representative Marshall, if you look at line 31 at the end there, shall not be used until they're shown to be free of risk. So they're not to be utilized for setting pretrial conditions until they can be demonstrated to be free of bias, as defined by subsection 1A up above. And then that final sentence is simply to say they could absolutely expend funds to use them in the background while they figure out if it's an appropriate tool or not. But before a defendant would be affected by it, it should be validated.
Mr. Chairman, another question. Mr. Chairman and Representative Cheney, it appears to me, I understand now what you're saying. I guess I would suggest it would be virtually impossible ever to show that any computer-driven algorithms are free of bias. I can't imagine in my mind how that would ever, under any conditions, be possible to show a lack of bias, because bias would still ultimately have to be determined by a human being looking at the things that have happened, and that human being himself might have bias. But I'm confident I would rather trust judges and others in this business of bias and not even get into this business of computer-driven algorithms.
Representative Cheney.
Mr. Chairman, Representative Marshall, I don't disagree with you. I will say that if you look at how we've tried to define free of bias, though, we give them a sporting chance. And that's to take the data that comes out the other end and look for statistically significant variances based on protected class alone, as opposed to they can't be explained by other factors such as criminal history and so forth. But.
Mr. Chairman, one more comment and question. So I think I could support this if we just used the idea to outlaw them altogether. I'm really uncomfortable with the idea of even bringing this business into the trial of human beings. You know, artificial intelligence and all of the things that we're getting close to, I can see the day. If we're not careful, that much of what we do in the process, in the due processes of the law, might gravitate to this whole business of computer-driven algorithms and artificial intelligence trying to determine who, when, what, why. He said, she said. I'm very uncomfortable with that. And I would just agree with outlawing them altogether, period.
Thank you.
Thank you. Representative Hartkin.
Thank you, Mr. Chairman. Representative Cheney, do you know, is it Ada County that uses this?
Representative Cheney.
Mr. Chairman, Representative Harkin, I'm aware that Ada and Canyon are using a system. The Politico article that I've included in your packet identifies a couple of systems. I've spoken with the good folks at Ada County. They've assured me it's not that system. It's a different system that is fully transparent. So as I understand what they've explained to me about Ada County system, it would not run afoul Based on the explanation I received, it would not run afoul of the requirements of this bill.
Follow-up.
Hello.
So did they tell you that it is not an algorithm, but it's an actuarial?
Representative Cheney.
Mr. Chairman, Representative Harkin, no, I think I've outpaced my pay grade.
Well, it probably outpaces my pay rate too, but I did dig in a little bit, and I used some of my connections over at the Supreme Court, the administrative office, and the program is called a PRIA. It sounds like a car, doesn't it? But it's not, and it is Idaho's application of the Virginia program. It is not anything like ProPublica, which is just a little slanted, in my opinion. But this particular program asks 8 questions, and there were 8 questions that I used to hear the judge ask. So now the computer asks these 8 questions. The most serious current charge, is your most serious current charge a felony? Do you have other pending charges? Do you have a criminal history? You have 2 or more failures to appear, has 2 or more violent convictions, has lived in the current residence less than 1 year, has an unemployment within the last 2 years, has a history of drug abuse. These are like the toolkit the police officers are using. It's one more tool that the judge uses. He or she totally then gets to use their own discretion of whether or not to set bail, whether or not to allow out on pretrial release, which is a big boon to the counties, to not have this person in jail. They obviously use many other questions, and the district attorneys or the defense attorneys are also on board with this because they have, anything goes afoul of a defense attorney and your case is not going to go very far. You know that. As an attorney, I don't have to tell you that. But it's a very transparent process and a very transparent tool. So I guess my question is, if we know the programs that are being used in Idaho are fully transparent, they're not algorithm, they're really actuarial, are we not just kind of getting ahead of ourselves because of a movie and quite possibly an article written by people in New York City?
Representative Cheney.
Mr. Chairman, Representative Harkin, I don't think we are getting ahead of ourselves. While I am confident that the Supreme Court tries to apply uniformity and expects uniformity, I'm aware that they don't always get uniformity across the state. I left the meeting with Ada County without any alarm about the way they were using the program, which, as I read it and as I understand it, does not run afoul of the bill that you have in front of you. But as it relates to anybody could bring any authority into a courtroom and ask the judge to accept it, and that's the judge's prerogative, the judge's discretion whether or not he or she accepts it. But that having been said, by the same token, there could be 44 different programs theoretically being used by. Well, there could be 88. There could be 127 different programs being used as each side tries to advocate for the accuracy of their own system. Maybe the prosecuting attorney's office gets one, the public defender's office gets another, every private defense counsel in town gets a dozen others. And so I don't think it's really getting in front of anything to say, okay, if you will, at a minimum, the Ada County standard is the standard.
Okay, just one follow-up. Also, maybe it's more a comment. This tool, it doesn't even include any recommendations for bail, nor does it give recommendations to the judge. It just shows them a percentage of their risk.
Mm-hmm.
Representative Cheney, do you want to comment on that?
I'll wait till closed.
Okay. All right. Professor Michael, is he still here? Yes. I can't read your last name, I'm sorry. You'll identify yourself.
Chairman Daley, members of the committee, thank you. I am Michael Ekstrand. I am an assistant professor of computer science at Boise State University and hold a PhD in computer science from the University of Minnesota. I would like to make clear before I get into my testimony that I am speaking here for myself as a concerned citizen with relevant expertise in the technologies that we are discussing, and I am not in any way representing Boise State University. So my research is in bias and discrimination in algorithmic systems, the way that it expresses, the sources of it, the impacts that it has in the downstream uses of those systems. I also teach classes where students learn the skills that are needed to both build the kinds of systems that we are discussing and to perform the kind of validations and tests that this bill would require as to their bias. So the nature, the behavior, the outcomes, the implications of these kinds of tools, both in pretrial risk assessment, in criminal justice more broadly, and in many other contexts, is a study of very active is a subject of very active research. It is definitely possible to use data to improve outcomes. I do a lot of work with data, and I believe that it is possible. That I believe in using data to make the best, most fair, most equitable, most just decisions that we can. However, this needs to be done carefully. When we deploy a tool, the default thing any of these statistical or algorithmic tools are going to do is learn the patterns that exist in the existing data. If those patterns are a reflection of bias, then it is going to naturally learn and replicate that bias. This understanding is instinctive to many computer scientists. When I'm discussing the issue with many of my colleagues, even who don't work in this area, the initial reaction is, of course, this is not going to be a good idea. They're just going to learn and they're going to replicate the patterns, the biased patterns in the underlying input data. It's possible to very carefully design tools that can mitigate that, but emphasis on the very carefully. And that is what I see this bill as requiring. It requires that care be done in the validation of the tool, and it requires that the data be made available to members of the public, such as myself, who want to go check the work of the vendors. The transparency requirements of this bill would make data available so that maybe in a year or two I could come back and tell some of you whether, from my judgment, it looks like the tool is behaving as advertised. Does the validation hold up with the data being provided or with the data that seems to be missing? But there's also, we need to understand the tools in the broader context of their use. It is a number that goes that goes in front of the judge and part of the decision-making process. The human dimensions of that are still being understood. There's much we do not know about how these tools affect the decision-making process. There was one paper that was presented at the Conference on Fairness, Accountability, and Transparency in January that looked at the human aspect of the decision-making process when these kinds of assessments are presented. And it found that the assessments in the context of this study actually increased the bias in the resulting human outcomes. They did not help. When you combined the algorithmic system and the human decision-making process, the result was even worse than this whatever bias the system might have had on its own. We need a lot more work to understand exactly what impacts these systems will have in our justice system. And I see this bill as saying, let us slow down, let us take the time to develop that understanding and make sure that if we are going to deploy these tools, they are deployed in a way that is responsible, in a way that is respectful of constitutional rights, and a way that promotes justice and equity for the residents of our state. These tools, as I said, these tools estimate, or they will learn the patterns that are in their underlying data. And I spent a chunk of my time last night reading a paper to prepare for today because just yesterday, a new study was released from researchers at Princeton that is looking at the statistical properties of the kinds of administrative records that are one source of input into tools such as the ones we are discussing. And finding that the current statistical techniques for understanding racial bias in these tools in these records, likely significantly underestimate the bias. So the data that is being used to train it is difficult to assess the bias, and the current tools that are being used to make those assessments likely underestimate it. This is very concerning when these records are being used as the input into statistical processes, whether those are to build models that are embodied as algorithms or whether those are to compute actuarial tables that then get executed on by humans. So this bill will allow the tools for public accountability of these tools. We need to be able to subject them to scrutiny. Defendants need to be able to have access to the justifications, the motivations for the decisions that are being made about them. And then members of the public. As I see it, if you are a software vendor and you want your tool to be used as a part of the justice system in a representative democracy, then part of the price of admission is subjecting your tool to public scrutiny and accountability through the democratic controls of the government and of the ability for people to audit it, to speak of what they learn in that process with the representatives, and to exercise our democratic prerogative in overseeing what is happening with justice in our state. So I believe this bill brings many good tools. I also believe it could go even farther. Specifically, validating the fairness of a system is not a one-and-done situation. I'm glad that the proposed amendments emphasize this by requiring not just initial validation, but revalidation. But another thing that I did not see reflected in the bill text is that the validation also needs to be contextual. It's not enough if you take data from Virginia, or you take data from New York or from Georgia, and you use that to validate your algorithm's fairness or your model's fairness. Idaho is not Virginia or Georgia or New York. Our data is going to look different. We have our own particular concerns. And so the validation not only needs to be ongoing, but it needs to be contextualized to the state of Idaho. We need to know that these systems, as deployed here, do not introduce or do not exacerbate any racial, gender, or other undesirable bias into the justice system. It also needs to be clear on what we mean by free of bias. I think the language is doing some good things there. There's things that as a computer scientist are still not entirely clear to me, but there's definitely things to work with here. There's also, the bill lists several things that are required to be provided as terms of records. One thing that's not quite clear to me yet is how that's going to interact with privacy claims. I'm glad trade secret claims are very clearly called out. But there may be records that are used as the input to this process that are legitimately non-public. How do we expect that to be dealt with? And what recourse is there if, as a member of the public, I am going and I'm accessing this data and it seems that there's something necessary that's missing? There's several stages, particularly there's several stages to the process of building and training one of these models. You have the raw data records. You then code them and you process them. You make decisions such as, are we going to treat the number of, are we going to look at your criminal history in terms of a number of convictions or a number of cases? Are we going to do some kind of binnings? We just ask, do you have a prior criminal history or do you have a conviction in the last 5 years? Do we get access to the records before or after that decision was made? In order to validate and understand and assess what the algorithms are doing, we need to have access to the records and to the decision-making process across the entire pipeline. Why are the decisions being made that they are? Why are the decisions in terms of binning being made the way they are? How do we assess the effectiveness of the algorithm? How do we assess its fairness? What recourse do we have if it seems that something's missing or if we have additional questions? That concludes the remarks I've prepared. I stand for questions.
Professor, would you spell your last name for the secretary, please?
E-K-S-T-R-A-N-D.
Thank you. Are there any questions for the professor? Representative Wintrow.
Thank you, Mr. Chair, and thank you. Could you tell me your last name again? I'm sorry.
Ekstrand.
Ekstrand, Dr. Ekstrand. Sorry, my blood sugar's a little low. We've been in committee a long time. Could you help me understand? There's a few questions I have. I'm not sure if you can answer all of them, but I'm trying to understand, number one, how these algorithms are created. Are they correlational data? So And because we know that, for example, race and income correlate, so that might draw a bias. I think we all agree we don't want biased systems. So I'm just trying to figure out how some of these algorithms are created and developed. I need to know what we're using in Idaho, if at all anything. I know I was reading a Department of Justice document, similar, it reminded me of what Representative Parkin was talking about, but differential between qualitative and quantitative and how we use this together and how those might help with risk assessments. I mean, the whole goal is to try to look out for public safety, but we don't want to do so in a way that's biased. But tell me how all this works and who's using what here in Idaho.
Professor.
Chairman, Representative Wintrow. So I cannot speak to specifically what is being used in Idaho. I would dearly love to know. I found the information on that not super easy to find. But as far as how they're created, it differs from system to system, but the basic idea is very correlational. The fundamental idea of these systems is we have a large set of records of cases, and we have outcomes. And the cases have the various features, whatever is recorded for that case. The answers to questionnaires such as this, some systems use a much more extensive questionnaire, and then you have outcomes. Whether the person was released or not, you have outcomes as to if they were released, whether they were arrested for a crime while they were released. And then the goal, we use statistical techniques. There's a wide range of techniques. We basically use statistical techniques to try to predict the outcome using the pre-outcome features of the case. There are going to be correlations, and one of the significant areas of research in the issue of fairness and justice in algorithms is understanding those correlations, identifying them, and then deciding how to deal with them. There are techniques to remove the correlations that may not be what we actually want to do, but the techniques exist. But they are very correlational. The core idea is learning the statistical function that's going to be able to predict, given a case history, what its likely outcome is going to be. They're severely limited in that there's a set of outcomes we don't have. Of the people who were detained, we do not know what would have happened if they would have been released. And so there's some real limits as to what we can learn there. The same principle applies no matter whether the output is a computer model that we run or whether it's a table that you can run as a person. There has been work on how you take machine learning models and use them to build checklists where you check the boxes, add up the numbers, and you get the result. The underlying principle is the same. The only meaningful difference is how we use the result. But the basic mathematics, the basic statistics are the same in all these tools.
Representative Marshall.
Mr. Chairman and Dr. Ekstrom, in the legislation, it uses the concept free of bias means that an algorithm has been formally tested. Would you respond to the notion in your way of looking at it, what formally tested means?
Professor.
Chairman, Representative Marshall, that is one of the things that is not clear to me in this bill. Because in our notion, formally tested can mean two things. One, there is a concept of formal verification in computer science that's not really applicable to these kinds of systems by and large. It's the idea of building a formal mathematical model of the system's inner workings that can prove that such an occurrence will or will not happen. This is common in safety critical systems, such as medical systems, such as avionics control systems, where you want to do things like prove no matter what input the pilot gives, the computer is not going to put the aircraft out of tolerance. But when we're dealing with a statistical system like this, that concept has less applicability because the outcomes are not just of the way the computer code is written. The computer code that gets written is code to learn patterns from data. The outcome is what happens when it learns those patterns from the data that we have. So formal testing in this context, to me, would be a well-documented evaluation protocol that takes the data that the system was given, additional data if we have it, the system's operation itself, looks at the system's outputs, and statistically tests them for properties indicative of bias. That cannot be the end of the story because bias, as you noted in your comments earlier, is a very difficult concept. There are many different definitions, some of which are not possible to simultaneously achieve. One of the things that's well known in our research community is that there are types of bias that you cannot have together in most that you cannot avoid together in most realistic settings. You have to have some of one or some of the other. So we can have, once we have a formal definition, we can have this formal statistical test that says, yes, by this definition, this type of bias, we cannot statistically detect the presence of this type of bias in the system. We could write a report about that. We could document the results of all those statistical tests. I would consider that to be a formal test. We will always have this informal stage of how did we decide on that definition of bias, and that way to actually turn it into math. And how did we, when we had to make a trade-off, why did we make that one?
Mr. Chairman, a follow-up. Mr. Chairman and Dr. Ekstrand, so given what you've just said, and given the language that you've used, likely underestimate, needs to be contextual. Evaluations have to be ongoing. I'm going to suggest that it's virtually impossible to ever get to the end of this, and just wonder if you'd comment on that.
Professor?
Chairman, Representative Marshall. Impossible is a very strong word, but it is incredibly difficult and incredibly expensive. And
thank you.
Did you have another comment? Representative Ehart?
Mr. Chairman, for a motion.
A motion's always in order.
All right, I move to send HB-118 to general orders with amendments consistent with draft DRRCB 243.
Are there any comments on the motion? We do have some other people who want to testify, but the motion's on the floor, so. Okay, just as a comment to follow up to Representative Marshall, I quoted Henry David Thoreau in committee a while back. It said, it's not what we look at, but what we see. And that's part of what we're dealing with here as well. Thank you. Are there any other? Okay, so we have, let's see, Mark Manuel? Is that the way, did I mispronounce your name?
Slightly, Manweiler, thank you.
Manuel, okay.
Mr. Chairman, members of the committee, my name is Mark Manweiler. I'm a criminal defense attorney. I've been practicing criminal law for over 35 years, anything from barking dogs to capital murder cases, mostly in Ada County. Do quite a bit of work in some of the neighboring counties and also in the federal courts. I'm here today on behalf of the Idaho Association of Criminal Defense Lawyers. As Alyssa Massoff mentioned earlier, we have over 400 attorneys in our organization. And I'm a member of a subcommittee we have, the legislative committee, that's been tasked with responding to this bill, as well as some others. Just so you know, a complete array of my biases, since that's what we're talking about. I'm also a member of the Idaho Sheriff's Association, as strange as that may sound. I'm a member of the ACLU, which may have a contrary view of this bill than that of my association, the Criminal Defense Attorneys. I'm in the NRA and the Idaho Conservation League, so I kind of cover all the bases. First of all, everybody here can agree that racial bias is a bad thing, and nobody's in favor of it, least of all our organization. However, with all due respect to Vice Chairman and Representative Cheney, who was kind enough to provide me with a copy of his proposed amendments to this bill, in our view, this is a solution that's in search of a problem. We don't need this bill in Idaho for a number of reasons, some of which Representative Hartgen has stolen my thunder on. But I kind of want to explain to you all, as I understand it, what's going on in Idaho. A lot of the studies that are being used in favor of this bill are national studies that have absolutely nothing to do with what's going on here. I think one point that kind of gets lost in the shuffle is with any pretrial assessment program, the final decision's up to the judge. These things are really just tools. The judges aren't bound by them in any way, shape, or form. They are free to disregard them or give them as much or as little weight as they see fit. This is just one of many tools that judges consider in determining whether to release somebody on their own recognizance, whether to release them on conditions, whether to release them on a monetary bail, or some combination thereof. Our judges are intelligent, they're thoughtful, they're dedicated, they are experienced in the criminal justice system, and these decisions are best left up to them with a minimum of oversight, in my view, by legislative and regulatory bodies, because they're the ones that deal with this stuff day in and day out, and they know what they're talking about. And I do think it's important to get the input of law enforcement, both from the side of the police and the sheriffs, as well as the prosecutors, on bills like this to understand what's going on. This particular piece of legislation, in my view, disregards basic science and what's been going on around the country in the last few years in the area of pretrial risk assessments. Representative Cheney alluded to the use of these tools in sentencing and other things, and later on he recognized that this bill has nothing to do with sentencing at all. This is strictly a pretrial risk assessment bill. I'm quoting an old friend of mine, Gary Rainey, who used to be the Ada County Sheriff, and he said in an article the other day, and he gave me permission to plagiarize him, to illustrate what we're talking about here, anyone who's ever had a teenage driver and has had to buy car insurance for their teenage son or daughter knows the difference in premiums between a teenage driver and an adult driver. And the difference is very simply explained, and that's because insurance companies know statistically that teenage drivers are a far greater risk to get in an accident than an adult driver is. Now, you apply this same logic to the issue of who do we release from jail when we don't know whether they're guilty or not. And there are certain things that we do know that are statistically proven. They're not up to debate. It's not a matter of bias. One thing we know is that younger people are more likely to commit crimes than older people. We know that somebody that has a prior arrest or a prior record is more likely to reoffend. We know that somebody who doesn't live here is more likely not to show up and appear voluntarily in court. These things are just common sense, and they're statistically provable, and they have been proven. In fact, at this point, we have millions and millions of outcomes, as the good professor referred to base this data on. This is not a new idea. It's been analyzed over the last many years. And just so you all know, the idea of pretrial risk assessments is not new. The federal courts have been using it since 1984. In federal court, there is no monetary bail whatsoever. A defendant is either detained or he is released based on whatever conditions the judge sees fit. There are 4 states right now that have a pure non-monetary bail pretrial release system, and those are Kentucky, Illinois, Oregon, and Washington. In addition, in Idaho, to bring this back home, our juvenile system has operated on a non-monetary bail, purely pretrial risk assessment system for many, many years. So we've had that here. We just don't have it yet in the adult criminal system. Now, for pretrial offenders or pretrial defendants, I want to just throw out one little statistic for you, and I think Judge Cawthon may have provided this to you. I understood he talked to this committee a few weeks ago. And I'll just focus on Ada County because that's where I'm most familiar, or what I'm most familiar with. On a particular day last month, January 25th, Ada County Jail, that has an 1,100 bed capacity, had 1,024 inmates. And I got to be careful here because I see Sheriff Bartlett, his legal advisor here, so I'm not going to misspeak. But of those 1,024 inmates, 575 of them were pretrial detainees. They hadn't been convicted of anything. They hadn't pled guilty to anything. They hadn't been sentenced to anything. They'd merely been charged. So over half the jail population is in there on basically an unproven charge with the presumption of innocence. The cost to the taxpayers for that in Ada County is about $95 a day. Now, pretrial risk assessments are currently done in Idaho in approximately 31 of the 44 counties. And the system that's used in Ada County, and again, Representative Hartgen alluded to this, is called IPRAI. The acronym is IPRAI. It stands for the Idaho Pretrial Assessment Inventory. And as the representative correctly pointed out, it's a very simple system. It involves 8 objective questions, none of which talk about protected classes or racial, sexual, or other religion, color, creed, any of that. None of the questions deal with that. And the representative pointed out the questions. They're basically objective questions about a person's criminal record, the nature of their current charge, their prior record, whether they failed to appear, do they have any crimes of violence, have they lived here for more than a year, have they been unemployed in the last 2 years, do they have a history of drug abuse. Now you'll note in the bill, and I'm going to focus on the potentially amended version, protected class has 5 categories: race, color, religion, sex, or national origin. And as you can see from the questions in the IPRAI assessment system, it doesn't ask any questions about any of that. It can't possibly be factored in as a bias because it's not dealt with in the questioning. And what happens is when somebody is arrested in Ada County, and some of the other counties have different versions of this. My understanding is Canyon County has kind of a hybrid version. But in Ada County, the person sits down and is asked these 8 questions. They have the option to choose whether or not to answer the questions. But the data, some of this data can be gleaned from the NCIC, the National Crime Information Computer, or from BCI, the Bureau of Criminal Identification in Idaho. And basically, of these 8 questions, one of which has a total potential of 2 points, and that's the question that deals with have you had 2 or more failures to appear. Then the judge is given a score, a gross score between 1 and 9. And what that score is designed to tell the judge is 2 things. One, what is the person's risk of flight, of not appearing? And 2, what's their risk of committing another crime if they're released pending trial on the current charge? A score of 1 is good, a score of 9 is bad. Having a 1 doesn't mean the judge is automatically going to release you on your own recognizance. Having a score of 9 doesn't mean the judge is automatically going to impose a gigantic bail. Again, it's still up to the judge. There are some structural problems with the bill as I see it. Number one, it doesn't say who's going to make this determination as to whether this algorithm has been validated. Who's going to do it? The bill doesn't say. Anybody can argue that it's valid or not valid. Representative Cheney's not going to do it. He's too busy. The professor at Boise State's not going to do it. This committee has no time to do it. The bill is fatally flawed. It's a good idea to eliminate bias, but number one, it's a problem we don't have in Idaho. And number 2, it doesn't say how this problem is going to be addressed. Number 2, who's going to pay for this validation? Is it going to be the state? It talks about the state or the political subdivision is going to have to go through this process. It doesn't say who's going to pay for it. Is it the county? Is it the city? Is it the judicial district? Is it the state of Idaho? The bill asks more questions than it answers. This proposed legislation asserts that assessments that are quoted in these national studies shouldn't be used because they're racially biased. One thing that this bill doesn't address is the financial bias of the current system we have in Idaho, which allows rich people to post million-dollar bails and poor people who are arrested for vagrancy or being drunk in public or violating a park curfew, and they're homeless and they have a $300 bail, they can't post bail, so they sit in jail for 45 days until their pretrial conference comes up, and all the taxpayers provide them with clothing, housing, and 3 meals a day. It's a dumb system, it's outdated, and that's much more important in our view, the financial bias with the bail system that we have, than a theoretical potential problem down the road if some of these counties decide to go to computer algorithms. And I'll be the first to admit that because we have 44 counties, some of which don't even use pretrial assessments, they're not mandatory, they're optional. And the bigger counties with more personnel and manpower they're more likely to use them, and that's kind of what I see happening. But this isn't a problem yet, in our state anyway. The real big picture here, the broad brushstroke is, recently some of the states, New Jersey, New Mexico, and California, as well as the District of Columbia, have gone to a hybrid system for pretrial release that basically emphasizes pretrial risk assessments, but does allow the judge in certain limited circumstances, if they make a finding by clear and convincing evidence, to also impose monetary bail. And there's basically a trend, it's a snowball rolling down a hill in our country, that eventually everybody is going to have either a no bail, pure pretrial release system, or they're going to have some hybrid form of that. And the people in the bail bonds industry are not stupid, they know that. So they're the people that are really pushing this bill, the American Bail Association. And this is a preemptive strike by the bond industry to try to get your attention and get you leaning against what's coming, and I can tell you it is coming in Idaho. We'll be introducing legislation next year to ask the legislature to approve a constitutional amendment to get rid of monetary bail, or at the very least go to a hybrid system, because the purpose of pretrial detention is twofold. Is this person going to flee, and are they a danger to society? It shouldn't be about how much money they have. In other states and the federal, like I said, the federal government's recognized it since 1984, and their system works beautifully. And obviously, people can nitpick and attack details of any system. No system designed by human beings is perfect. It never will be. We all know that. But this is a tempest in the teapot. We don't need it. It's a waste of time. It's a waste of money. It's a problem that we don't have in Idaho. And we're respectfully asking you to vote against sending this bill to the floor. Thank you.
Are there any questions? Representative Marshall.
For a motion?
We've already had
I understand that.
Okay.
I'd like to offer a substitute motion.
Okay.
That I move that we hold House Bill 118 in committee.
Okay. Okay. We still have additional witnesses, but we now have a motion and a substitute motion. So, Representative Gannon.
Thank you, Mr. Chairman. And Mr. Manweiler, could you elaborate a little bit about your last remark that next year we're going to have a legislation, or at least a presentation of proposals to change the bail system? Could you just very briefly elaborate on that?
Sure.
Yes.
Thank you, Mr. Chairman. Is this really relevant to the bill, what's coming up next year? I mean, it just seems out of order.
He did make a comment. He did make a comment, but it is beyond the scope of.
Well, I'm thinking in terms, Mr. Chairman, that there's been the statement that this is prospective legislation, and so I'm thinking, if this is really prospective legislation, what is is there something else going on here that we should know about?
Well, I'll rule that if that comes, we can deal with it when it comes. So you don't have to answer that question.
Thank you, Mr. Chairman. I'd be glad to talk to the representative about that.
Okay.
Off the record.
Okay. Any other questions? Representative Winthrop.
Thank you, Mr. Chair. And I just had one quick question. You were talking about the number of people that were being detained in Ada County right now being like 500-ish. And those are because they're there pre-trial, too risky to let go. Is that what you're saying to me?
Well, they're there because under our current system, which is a bail-based system, although we have a voluntary pretrial risk assessment, right now, as of that date, over half of the inmates in Ada County had just been charged with a crime as opposed to people that had pled guilty and been convicted. And that's why, because the purpose of pretrial detention is to make sure people aren't going to flee, they're going to show up to court, and that they're not a danger to the community. That's why the momentum is kind of overwhelmingly in favor of a pretrial assessment system. And it's been alluded to earlier, but the societal cost is not just the hard cost of housing these people. And remember, 10 to 20% of people charged with crimes actually are not guilty. Law enforcement does a good job, but they're not perfect either. But the real cost is they lose their job, they can't pay taxes, they can't pay child support, they can't pay their bills, and it's a cascading effect in terms of the drain on the economy. One study showed that last year alone it cost $13.6 billion nationwide to have people incarcerated just because they couldn't afford to post a bond, not because they were a risk of flight or because they were a risk to the community. They just didn't have enough money. So that's the real issue that's coming up, and that's why you can expect some further legislation down the road on this whole global issue.
Mr. Chair, just one more question then. So basically what you're saying is most of the folks that are sitting in 80 County Jail probably shouldn't be because they can't post bond.
I'm not saying most of them, but I'm saying there's a statistically significant percentage of them that if you really looked at the purpose behind pretrial detention, instead of just how much money they have, and I can tell you in 35 years, the monetary amount of bails has really gone up from what it used to be, way past inflation. That a system like this that allows judges to use this just as a tool is a better system from a macroeconomic point of view.
Sorry, Mr. Chair, I just want to understand what our presenter is saying to me then. So basically are you saying that we are not using pretrial successfully in Ada County because some of these folks probably could have gone through a risk assessment and be out in the community to go back to court versus sitting in jail?
I'm saying this iPray system has just recently gone online. And so far from what I've heard, and this is an issue where the judges are ethically prohibited from taking a public stand pro or con on policy matters like this. But I can tell you, every judge I've talked to loves this system. And I think as this system gets more and more in effect in more and more counties, you're going to see the number of people detained in jail go down. It's going to go down further when we get away from a pure monetary bail system, I believe. And I think this is one of those issues when the sheriffs and the defense lawyers are on the same page. The prosecutors and the bail bonds companies may not be. But this is an issue that makes sense for people that are involved in this system.
Thank you. It is now 4:30.
I'm sorry, just quickly.
Just a reminder.
Thank you, Mr. Chair. Now I forgot my question.
Well, I hope I answered the previous ones. But.
Okay, are there any other questions for? All right.
Thank you very much.
Kathy Grismeyer.
Good afternoon, Mr. Chairman and members of the committee. My name is Kathy Grismeyer. I'm the Policy Director with the ACLU of Idaho, and we stand before you today in support of House Bill 118 and wanted to offer some comments in terms of our background in supporting this issue. And they primarily resolve around three issues: the inherent racial bias built into these programs, the error-prone rates, as well as the lack of transparency around the data and how these systems are created. We know that even in Idaho, despite having lower numbers of diversity, we still over-incarcerate Black and Hispanic individuals at rates that far exceed their total representation of the state's population. In fact, in Idaho, according to the Sentencing Project, we rank 5th in the U.S. in terms of incarceration rates for Black people as it relates to our total population of Black folks in Idaho, which is 0.8% of the total population, and 3rd in the country in terms of incarceration rates for Hispanic prisoners, despite them only representing 12.3% of our full state population. When we're looking at things like addressing or assigning points to somebody's previous criminal conviction, we also have to recognize that there are some individuals in this community, primarily from a community of color standpoint, who are over-policed, who are over-incarcerated, who are overcharged, who end up presenting a much larger set of the data set in the state as it relates to the data that's input into these programs. These algorithms are also not neutral truth tellers, so you have tools that are designed and employed by humans who carry their own cognitive bias in terms of how these tools are created. And they contain multiple opportunities for error in terms of the raw data itself, the assumptions made during the algorithmic construction, and finally the way that the tools are interpreted. And while some of these tools do provide some transparency, many don't make public their risk factors and weighting systems in terms of the decisions made in creating the tools, and that some of them are not independently reviewed. So it's in many cases the raw data from a pretrial algorithmic tool is never shared due to proprietary concerns, and validation studies omit the justifications, weights, or cutoff decisions made by programmers in determining how to calibrate a tool. Absent the ability for independent and peer review, we're stuck relying on the small handful of folks who do these programs. And you've heard that this is not an issue in Idaho. I do want to remind this committee that the ACLU, in fact, has sued the state of Idaho for its prior use of an algorithmic tool as related to the Department of Health and Welfare and our KW v. Armstrong lawsuit that was filed in 2014, which was struck as unconstitutional. The Department of Health and Welfare had been using a tool that had been inputting data and assessing the amounts of money that adults with developmental disabilities would be receiving from a Medicaid disbursement payment. When there were cuts in that Medicaid funding program, we had folks contacting our office. We reached out to the department to better access and understand how those determinations were made, and the department said that they were trade secrets and therefore not subject to disclosure. That ended up becoming a class action lawsuit, and the tool was found unconstitutional. In response to that lawsuit and to that settlement with the Department of Health and Welfare, we're now working with a new tool programmer out of Oregon, the Human Services Research Institute, where we're analyzing Idaho-specific data to create an Idaho-specific tool where members of the public, the ACLU, adults with developmental disabilities, so those most directly impacted by this issue, are going to be able to review the data and better understand how the tool is going to be programmed for future use in terms of how Medicaid disbursement payments are going to come out, as well as be available to independent assessment. So I offer that explanation. While not a direct correlation in terms of a pretrial risk assessment, it does have very similar concerns in terms of how the data was assessed, the department not sharing how those decision-making factors were being considered or weighted, and the disparate impact to adults with developmental disabilities, which again resulted in a lawsuit from our office and a ruling of unconstitutionality from state court, as well as a ruling upheld in the Ninth Circuit Court of Appeals. I do want to address some of the improvements that have been made in the bill. Certainly appreciate Representative Cheney's willingness to include in Section 4 on page 2, looking at lines 1 and 2, that the assessment tool will be validated within every 2 years. We want to make sure that the data continues to be assessed and reviewed. These tools are not stagnant in time and should continually be revalidated. One thing that's missing from this bill is the rate of false positives. So when the tool determines that somebody is a risk, but actually they're comparing group risks as opposed to an individualized assessment of that person's potential chances of failure to appear or likelihood to reoffend, which also should be considered through 2 different sentencing options, right? Your risk for failure to appear could simply be addressed through a text message reminder program. Your likelihood to recommit a crime or to pose a public safety threat could be addressed through a different pre-sentence determination in terms of supervision and maybe the need to have a hearing around appropriate conditions of bail. I also wanted to add that the second part of using these tools is not only the output that comes from the tool, but also how judges are interpreting the data that comes from the tool and the judicial discretion that's still provided. I know we're talking about studying Idaho data, and certainly it sounds like we need to learn a little bit more about how these programs are being used in Idaho and what data is being considered. In Kentucky, I read a report where judges were using these pre-trial risk assessment tools, and they were not ultimately resulting in less people being detained at a pretrial standpoint. So they weren't necessarily effective in decreasing the number of people who are being held from a pretrial standpoint, which we know is one of the factors in terms of jail overcrowding. And we also believe that there could be additional solutions instead of using these pretrial risk assessments, which do create problems, which have created problems in other departments here in the state. We could see things like adequately funding our public defense system so that when defendants are going before a judge for an initial bond hearing, that they have appropriate legal counsel there to make the arguments for their clients. We could be expanding text message reminder programs. We could also be looking at creative solutions for less restrictive alternatives to jailing. And with those comments, I'm happy to stand for any questions.
Any questions? Okay.
Mr. Chair, quickly.
Representative Wintrow.
Thank you, Mr. Chair. Ms. Grismeyer, very quickly, do you see a lawsuit in our future on any of that? Do you know of any of the algorithms or programs that we're using? And I mean, do you see any problems?
Chairman Daley, Representative Wintrow, at this point, Right now, no, but I can say that I have a document which I could send to you, which does have a timeline of other ACLU filed lawsuits against algorithmic programs, not only in the criminal justice system, similar to cases like we did in the KW v. Armstrong lawsuit, that do list a number of lawsuits we filed around the lack of transparency, the bias that's built in, the error-prone, that the programs are error-prone and how they're determining outcomes, and I'd be happy to send that to you if you'd like.
Representative Gannon.
Thank you, Mr. Chairman and Ms. Griesmeyer. So I'm having some question as to, usually the criminal defense lawyers and the ACLU are aligned, and we've got experienced criminal defense lawyers that I have a lot of respect for, who seem to have a different viewpoint. So could you explain, or maybe explain why there's, what the difference is in your viewpoints with
Ms. Griswold.
Chairman Daley and Representative Gannon, I think the KW lawsuit is really a great example in terms of the concerns that the ACLU has, not only in just the application of these algorithmic tools from a criminal justice standpoint, but in the broader use of how these tools are built and how they might deny access to folks. And so it really comes back to questioning around how the algorithms are used, what data is being accessed in terms of bias that's built into the data, then that bias is then programmed in by the programmers who are creating said algorithmic tool, and then their application by state agencies or departments. Oftentimes these programs are sold or contracted with state agencies through third-party contractors who may not be subject to public records requests, or they become accessing information around data they've used, or their weighting factors or risk factors becomes difficult to ascertain in terms of that public transparency piece, which is exactly what the Department of Health and Welfare ruled, saying that it was a trade secret. They couldn't disclose how they were making those budgetary calculations, which had significant impacts to adults who were seeing their Medicaid dollars go away, where they couldn't have home caretakers provide, medically necessary care for them because we just didn't know why. It was a secret that wasn't being disclosed. And so because of those reasons, and seeing how they can be applied in these pretrial risk assessment arenas and how they've been applied in other states, I think part of this is a preventative concern that we have, but based on how we've seen these tools used in real application already in Idaho.
Thank you. Any other questions? Representative Marshall.
Mr. Chairman and Ms. Grismeyer, did you say you were in support of the bill or opposed?
Chairman Daley and Representative Marshall were in support of the bill.
Chairman Daley, I guess my comment would be, it seems that everything you said would argue against this bill. I don't understand. It seems totally disingenuous to say you're in favor of the bill and then to argue the way that you did.
Chairman Daley and Representative Marshall, I appreciate your comments on that. Certainly, I think if ACLU had its way, we wouldn't see a pretrial risk assessment tool in Idaho at all. Seeing that that's maybe not a reality in terms of how counties are already using these tools and the sideboards that this bill is attempting to add in terms of addressing the concerns around racial bias, transparency, data collection, then we feel like we can make an accommodation in terms of the outright opposition we have, but realizing that this is an attempt to put some appropriate sideboards that we feel comfortable with if the state's going to continue to use these tools.
Well, Mr. Chairman, I would just comment that the arguments seem to be totally against the bill, and anyway, thank you.
Sure.
Any other comments? Okay, let's see. Tom Arkush.
Chairman Daley, thank you for the opportunity to speak. My name is Tom Arkush, and I am the lobbyist for the Idaho Association of Criminal Defense Counsel. I want to thank Representative Cheney for having an open forum for people to try and work through this so no harm is done in passage of this bill. I'd also like to tell Mark Manweller I've been practicing law for 40 years. I would just like to touch on one other aspect of the unworkability of the bill. I would like to tell Representative Gannon that the ACLU and the criminal defense bar are not apart on two things. There has to be transparency. There never can be a black box. We have judges. Secondly, you can't have bias. We all agree to that. The problem with the bill is, as Mark pointed out, it's a problem that we don't have in the state of Idaho that needs to be solved. The comments about the Hispanic population and being incarcerated has nothing to do with this bill. It was not an algorithm or a computer program that imprisoned these people. It was judges. That's not what this bill is about. The other ambiguity, other than formally validated free from bias, which even a PhD, Professor Ekstrand, couldn't define and is not found in the bill, is that this bill has spoken in its original form as it was going to examine processes. That was changed to computer programs and applications in the proposed new language. It's been spoken as of algorithms, and I would point out that an algorithm is merely a calculation. Adding two numbers together can be an algorithm. And I would point out that an actuarial, as Representative Hartung pointed out, is just adding up numbers. There's no inherent bias in it. And it's also been spoken of as a risk assessment tool. This bill needs to narrow down precisely what it's talking about so that we don't catch porpoises in the tuna net. We don't want risk assessment tools in the future to be prohibited. We don't want this bill to be used as a protectoral or unneeded impediment to the adaptive means to structure pretrial release possibilities now or in the future. That's the big fear we have about this bill. Thank you, Mr. Chairman.
Are there any questions for Mr. Arkush?
Thank you, sir.
All right. We have Jeff Clayton.
Good evening, Mr. Chair, members of the committee. My name is Jeff Clayton. I'm the Executive Director of the American Bail Coalition. I'm not just that, I'm also one of the nation's foremost experts on bail reform, pretrial risk assessments. Recently had published a peer-reviewed piece on this very issue in the UCLA Criminal Law Journal last year, which is worth a read if you have the time. I will tell you that this is the hottest issue in criminal justice right now. You may not pass a bill today, you may not pass a bill tomorrow, but you're going to have to deal with it at some point, and I don't really know what the solution is at this point, other than maybe to go where Representative Marshall is going and say maybe we should just not use them at all. But I don't know the answer to that. What I do know is, in speaking to my wife about this bill, I said, you know, there's a guy up in Wisconsin that said that men are inherently more dangerous as a result of these algorithms. And he found that discriminatory. And my wife chuckled and said, you know, I happen to agree with that because you go out and drink beer with your friends. And so you're much more risky than I am staying home and taking care of your new puppy. But, you know, bias in the system is a major problem. Obviously, 110 national civil rights groups have come out saying, don't use these things. And if you do, the main thing that they focused on was validation and transparency. And I think even if you can't get to this question of testing for racial bias and get a solution, don't overlook the transparency part. Like the professor, I have 21 statisticians that I could have evaluate any tool right now, but I can't get there. I can't get the data in order to be able to do that. It's been posited here that this is not a problem in Idaho, but I would posit the opposite, which is you don't know because they haven't been tested yet. And until they are, you won't know. I can also tell you that basing it on the Virginia risk assessment, these are common builders. There's 3 or 4 people in the nation that do this, and I can give you their contact information. They all are built in the same way, with pretty much the same process. I stood shoulder to shoulder in California with 55 civil rights groups to stop the atrocity there, which would eliminate the constitutional right to bail and condition people's release from jail on the results of these algorithms. I went down into a really bad neighborhood, invited in San Diego. As I got closer to the destination, the Uber driver said, "Sir, I think we need to turn around. This neighborhood, it's too dangerous for you to go into." And I said, "I'm going anyway." Around the table were African-American leaders from San Diego, and they said, "Jeff, whatever you do, stop these computers. And I promised him at the time that regardless of where this job went and where I ended up, that I would help expose this as an issue and let people make decisions for themselves, obviously. Transparency, I think, like I said, is the heart and most important piece of this bill, regardless of whether you're able to come up with some solution to racial bias or not. Let academics, let people who are able to do this work do it, because they will. They will if it's transparent. If it's an open source system that can be tested, you'll get the kind of information you want. And so if you don't do anything, do that. Also read Life, Liberty, and Trade Secrets by Professor Rebecca Wexler of Yale University. Read the article and say that it's okay for these people to have black box algorithms and assert trade secret protections within cases and stop criminal defendants from understanding it. And is it a problem in Idaho? I think it is, because who can submit a discovery request for the information on which the Virginia tool was built that now the Idaho tool is modeled after? How would any criminal defendant ever get that information and be able to conduct their own research and testing on it? The answer is they can't. Is this a legal issue? Absolutely it is. Read State versus Loomis, a case the U.S. Supreme Court denied cert. The due process issues in that case would make the tools used in Idaho fatally flawed from a due process perspective. And that lawsuit could be filed tomorrow. And certainly, it's not going to be by me, but certainly a criminal defendant who faces a more severe consequence could say, wait a minute, there has to be a due process warning, like in State v. Loomis. Now, let's talk just a little bit about the benefit. It's posited that the benefits of this, regardless if there's bias, simply would outweigh it, and we should proceed forward. Megan Stevenson's a professor of law at the Antonin Scalia School of Law at George Mason University, issued a landmark report discussing risk assessments and practices, and found that not only did they not decarcerate, they increased failures to appear and new arrests while on bail, and did studies of several different states and several different applications of these, and found no evidence that they improve the system or make the system any better. Final point, I guess, and I'll kind of combine my comments there, is, it was raised that the federal system would be some great alternative to this. And, while it's been suggested that we're doing some kind of a preliminary strike or something, that's ridiculous. No state is listening to this anymore. And the reason is because the federal system of risk-based preventative detention using these algorithms has increased the pretrial detention rate from 24% when it was passed in 1984 to 72% today. And why? Why is that? And the reason is, if you read Professor Robert Worth from Rice University's recent article on this, he says that these risk assessments, along with the expansion of the penal state since 1970, are the reason why we have generational mass incarceration. And let's think about why that is. Because there's no remorse. There's no healing. There's no nothing, because once you're dangerous, you're more dangerous the next time. You're more dangerous the next time. You're more dangerous the next time. And it doesn't matter. And people realize that when they get, and you're setting them up to fail over time. And that's exactly, I think, what we have happening here. And when the ACLU testified against the Federal Bail Reform Act of 1984, they said, this is wrong to label people as dangerous because no subsequent trial could ever exonerate them. I think it's un-American. I think it's, frankly, un-Christian, because there can be no remorse. And I think embedding these continuously in the system is the reason why we're having all the problems that we have. And I think there was no algorithm prior to 1970, and things were going pretty well back then. And so I would encourage you, again, to, if you can't do anything, just make these things transparent so that you can get the information and that criminal defendants can get the information they need to defend themselves. So thank you for your time.
Representative Ehart.
Mr. Chairman, Mr. Argesh, wow, I said it wrong. Taylor. Oh, my goodness.
Oh, it's Jeff Clayton. My name's Jeff Clayton.
Clayton, I'm sorry.
But I can play anybody you want. I can try.
No, I try to keep notes. All I can say is, wow, I could not take notes as quickly as you were speaking, and I would just ask, because your information was hugely relevant, not that everybody else's wasn't, but I think I followed this better. But might it be possible to get a copy of your notes?
Well, yeah, actually, I'll write something up because I don't generally
Never mind.
do that. I was on the debate team in high school and college. That's why I talk so fast. So I will.
You did a good job.
Thank you.
Are there any other questions for Mr. Clayton?
Thank you.
Thank you very much.
Have a great evening. Thank you.
Michael Kane.
Thank you, Mr. Chairman. I don't want to prolong the agony. I will try to be as brief as I can, but we have a lot to talk about. Representing the Sheriff's Association. First of all, I have the document that we've been talking about for half the day. It's unfortunate I didn't realize nobody else was going to bring it, so if your page was just walked out, if I may approach, I have the actual Ada County Sheriff's pretrial risk assessment for your review.
Yes, just start it over there and you can pass it around. Right.
It's unfortunate in some ways that I'm last because I feel like we're starting in the middle with the conversations we've been having. I think it's very important for you to understand what pretrial is and how it's used in this state. As has been alluded to already, this is not a finding of guilt. It is simply a determination as to whether or not a person will get out of jail immediately while he is awaiting trial on his criminal charges. Now, the first thing that you need to understand is that pretrial is a court process whereby the judges determine whether or not to let them out on their own recognizance, a low bail, or keep a bail in the middle ground, or keep a bail in the high ground. Why do the sheriffs care? Well, one, we are charged by many courts, administrative judges throughout the state, of actually assisting the individuals who want to get out of jail with the pretrial questionnaire process. And what you're looking at, what you're holding in your hand, is simply a questionnaire. And you look at the bottom and you see that there are certain numbers. If you've got a certain number of felonies or failures to appear, you just assign a score to it and you just add it up. And there's a second page in which sort of mitigating factors are allowed. And at the end of the day, that is simply given to the judge, and the judge then says, all right, we'll let you out on your own recognizance if you do the following things. It might be anything. It might be wearing an ankle bracelet. It might be reporting in every month or so. It might be committing no more crimes. Again, it's an agreement between the individual and the court. And if there's an agreement and there's no reason to hold them in jail, that's important. The second reason that the sheriffs are so concerned is because we have no room at the inn. We've been talking about Ada County and Canyon County in particular. There are 700 people right now that are on pretrial release, let go by the courts upon an agreement with the court, because there is no room at the Canyon County Jail. There are 297 people in Ada County, similar, who would otherwise potentially be languishing in jail. There are still people that are in jail who were assigned bond. Why are they still in jail? Well, they may not be able to post bond. Why is that? It may be an incredibly serious felony, or it may simply be that they have no ties to the community. Is a bondsman going to post bail for someone who, say, is an illegal alien? The answer is usually probably going to be no. So the question that we were faced with, and we are still learning as we go, we're on the fly here, as far as I know, I don't know that we have an algorithmic system in Idaho. I don't know of anybody. Nobody's been able to tell me. Maybe we'll learn as we go. But as things stand right now, I don't know of any. And so the first question we had is, the way the bill that's in front of you is written, this document, which can be filled out in pencil, could theoretically be called an algorithm because the bill you have in front of you uses the word process. And so on behalf of my clients, I reached out to Representative Cheney and said, hey, shouldn't it be a computer program or application? And he thankfully worked with me and very graciously has given you a proposed language that would go into, it would more call it a computer program, not a document similar what, to my knowledge, probably 90%, 95% of the counties are using. So there's that. The next question is, are we, by doing this, somehow impinging upon the ability of the courts to set bail, to make their individual decisions? And there's some language in here about that, too, that, again, Representative Cheney graciously inserted. Now, is it perfect? We think there are still some tweaks to be made. The bottom line is the bill you have in front of you is not ready for prime time, and I think everybody in the room pretty much recognizes that. We will commit to you, we will commit to Representative Cheney, we'll commit to the bail industry and the defense attorneys and everyone else in the room. We'll keep on working on this. There is some more work to be done. We commit to do that.
Thank you. Are there any questions for Mr. Kane? Okay. We have two motions on the floor. The first motion is to send it by Representative Ehart to send to the amending order. Oh, did you want to finish?
If I may.
I just wanted to...
It's not 7 o'clock yet.
It's not 7. I just wanted to reiterate to the committee what we have on the floor, and so we would keep members here so that we could have a vote. We have two motions, Representative Ehart and Representative Marshall, to the substitute motion to hold it in committee. So would you finish your presentation?
Certainly, and I apologize. So, Mr. Chairman, first of all, we're not ahead of ourselves. Mr. Manweiler was kind enough to tell us that 31 out of 44 counties are using this system, and not everybody's using the Ada County system. I see no issue with the Ada County system. The fact that you're looking at data right now shows that they're doing it right. That's what we want. We want them to show what they're doing. The document I submitted to everybody in your paper packet shows that this has been a priority rollout statewide since 2017. The reason there are national studies that we're using is because we see the problem. If we saw, if we imported a bunch of Ford Pintos from the 1970s into Idaho, would we say those explosions didn't happen in Idaho, so we're going to ignore them? Really? We wouldn't do that. We would believe an explosion that happened in Pensacola or Los Angeles and get rid of the stinking Pinto. I'd like to address some of the comments made by Mr. Manweiler. And he said that you can't tell from the bill who would enforce this. And to his credit, his experience as a criminal defense attorney came out, because if he spent more time with civil, he'd definitely figure out a way to litigate that issue. Just kidding. There seems to be a little bit of a conflicting argument as well being brought forward. One, these are just tools. Well, first of all, these were just tools 20 years ago. Leave it at home, try to get an hour away from home, and see how many of you turn back around for it now. The more we use technology, the more reliant we become to it. It's past 4:30. My grammar's gone. I apologize, committee. If we have a standard to use, at first it's a suggestion, and over time it's going to become the expectation. And the juxtaposition that we heard today, though, was that on the one hand it's just a tool, it's just a suggestion. The judges are free to override it all they want. But on the other hand, the judges really can't figure out how to get these inmates out of the Ada County Jail without this tool. We have people being incarcerated that shouldn't be incarcerated because we don't have a tool. But it's not going to have that big of an impact. If your neighbor or your child or your cousin stands before a judge and the decision is whether or not to return to liberty, whether it's on a short term, like pretrial release, or on a long term, like sentencing, which I acknowledge this bill does not cover, you want to know the basis of that decision. You have a right to know the basis of that decision. And the problem isn't right now. And the car insurance actuary example doesn't hold for a couple reasons. One, the example was of a 15-year-old. You'll notice that the definition of protected class in the bill does not include age. We leave open the possibility of determining that a 21-year-old is a whole lot more likely to either not show up to court or to commit another crime than a 90-year-old. Go ahead. And number two is you don't have a document called the Constitution guaranteeing you low car insurance. There is no Geico Amendment. You do have a constitutional right not to have your religion or your gender or your race determine how long you are in the custody of the state. So it's not today that brings me the greatest concern. It's where we'll go if we aren't vigilant and we don't demand up front, as this technology is being adopted, that we do it right and we do it constitutionally. Representative Marshall has expressed concern, but if we just wait for the system that for some inexplicable reason has to rely on this system to figure out how to let people out of jail, then we are going to be doing the exact thing that you fear, and that is relying on these things way more than we should. Ronald Reagan said, "Freedom is never more than one generation away from extinction." Ronald Reagan. Freedom is never more than one generation away from extinction. We didn't pass it to our children in our bloodstream. It must be fought for, protected, and handed on for them to do the same. How many of you would have broadcast your location of where you're eating dinner 20 years ago? Some people are smart enough to still not do that. 20 years ago, I'm old enough to remember being told, don't pick up the phone. If you hear a voice on the phone, don't stay on the line because it's a party line. It's not your call. Being very careful about what information we gave out. Being very careful about what we said, what we shared about ourselves. How desensitized have we gotten to Google following us around 24/7? I go into Walmart and I get a notification on my phone that says, check out Walmart's deals, because I know where you are. So the desensitization of our culture toward technology and the pervasiveness of big data is remarkable, what we've come to accept. What are we going to come to accept in criminal justice? What are we going to get desensitized to? What are we going to fail to pass on to our children, as Reagan said? Once again, the goal is individual rights in our system, not efficiency. We accept inefficiency to guarantee each individual's rights, the right to know what system is being used against you and the rules of the game at the very minimum. I keep going back to the Minority Report as an example, and it is a really corny movie, but it seems really unrealistic, but it is set in 2054. When I think about all the things that desensitize us, not only about using technology, but sharing information, things that people say about themselves, things that people say about each other, we're fine being under surveillance, we invite surveillance. When I think about the other ways our culture is becoming increasingly desensitized, and then I think about any sort of nonchalant attitude about constitutional violations being shrouded in technology and being acceptable because it's wrapped in technology, I realize that if we're indifferent to constitutional violations or the risk of it today because it's out of sight and out of mind and it works, what will we be like in 2054? Ladies and gentlemen of the committee, this, as the last speaker said, at a minimum, we need transparency. I think that the definitions of bias are ready to move forward, but at a minimum, we need to be able to see inside the black box. And our defendants deserve to be able to have a system that not only acts appropriately in the human realm, but acts appropriately through technology as well. And I'd stand for any questions.
Representative Marshall, you have a question or comment?
I do not have a question. I just have a comment. I think that the preponderance of the testimony that's been provided today would compel us as a committee to adopt the motion that I offered, and that is to hold the bill in committee, and I would hope that we can proceed to that question as quickly as possible.
Okay, to reiterate, do you have
Just a quick
comment
question,
on the
Mr.
motion? Because there are two motions. We'll do the substitute motion first, which is Representative Marshall's motion to hold in committee. Then if that fails, then we'll vote on the underlying motion of Representative Ehart. So did you have a comment on the motion?
Mr. Chair, I had a question because I wanted to ask a question of Representative Cheney at the very beginning, but he sat before I could do that. Representative Cheney, if you'll yield to a question, and that is, for how long and how many stakeholders have you worked with on this bill? Like, what kind of problem solving and discussion has been going on? That might help me a little bit.
Representative Cheney.
Well, thank you. I know that Mr. Arkush came and met with me last week. Mr. Kane reached out to me this morning. I've spoken with the representatives of the courts, magistrate judge that the court set up for me to speak to, and with Mr. Clayton's organization as well.
Mr. Chair, for comment then.
Comment is in order.
Mr. Chair, I really appreciate, first of all the attorneys that testified. It's really awesome. The presentation style, incredible. And I do appreciate the fact that I think all of us want to reduce and eliminate bias. I am right there with you. I'm on a criminal justice team right now that we're trying to identify and prevent gender bias in criminal justice systems. So, you had me at hello on that. What I'm struggling with is this is just so much information. I'm having a hard time understanding it all, and I guess I would support I would support the substitute motion just because there's just so many unanswered questions for me, and I would prefer a working group come together and discuss some of these issues and figure out how we can go forward the best way for our state to make sure we are preventing bias, but that we are supporting the best kind of tools that our criminal justice professionals could utilize.
Representative Gannon, you have a comment on the motion.
Oh, thank you, Mr. Chairman, and I appreciate Representative Winthrow's work on gender bias because we have so many more men in prison than we do women, and maybe we can do something about that. I could, but anyway, I couldn't help but think that. And I appreciate all the testimony because obviously everybody put a lot into it, but I couldn't help but think that if our present system is so biased that we're third or fourth or fifth in bias, and this system would be biased too, but next year apparently something's going to happen. I don't know what, and I'm very disappointed that I don't know what. I think the best thing to do is to consider a bill like this in conjunction with whatever is going to happen to improve our system, which may or may not be as up to par as we want. So I will need to vote no and look forward to next year when we have everything on the table at one time.
Okay. Representative Zollinger.
Thank you, Mr. Chairman. I would like to make an amended substitute motion to send the bill to general orders.
Just send it to general orders without a committee recommendation.
Yes.
Okay. The bill as it was originally written. Okay, are there any comments on that motion? Or I guess that will be the first motion then, and we can't have any other motions. That's the third motion. So the motion then is to send it just straight to general orders without a recommended committee.
And I would be okay with that, and I would work with the committee in the coming days to pare it down, maybe just go with paragraph 4. As far as so that we have something on the books. We have a step in the right direction. So I'd be happy to speak to anybody who'd want to work with me on that in the event the committee's choice was to go that way.
Okay, so is everyone clear on the motion? The three motions. The motion which we will vote on first is Representative Zollinger's motion, which is to just send the bill as presented to the committee to the general orders. In other words, to be amended as we see fit on the floor. So we'll vote on that motion first. And we'll have a recorded vote. We'll have yes, we're having a roll call vote.
Mr. Chair, just for a quick question of like the parliamentary procedure, is my understanding that no matter what, if it goes to general orders, regardless of this committee's recommendations, people will do anything they want to it. And I mean, they'll have to pass it through the committee of the whole for sure, but.
That is correct. Either Representative Zollinger's motion or Representative Ehart's motion would open the bill up to any amendment on the floor.
Okay, this is the vote on the amended substitute motion made by Representative Zollinger. Vice Chairman Cheney.
Aye.
Representative Kirby. Representative Amador. Representative Zito.
Yes.
Representative Zollinger.
Yes.
Representative Ehart.
Yes.
Representative Scott.
Yes.
Representative Gosling. No. Representative Hartkin.
No.
Representative Marshall.
No.
Representative Ricks. Representative Troy. Representative Young.
Yes.
Representative Gannon. No. Representative McCrosty. Representative Wintrow. No. Representative Davis. No. Chairman Daly.
Yes.
1, 2, 3, 4.
Okay, the bill will go to general orders, 7-6 vote. Are there any other issues that need to come to the committee? The committee is adjourned.